Hello there. My name is Crista Hermance, and I'm an estate planning attorney. We're going to give it just a few moments to allow people to join the webinar. I am also going to put a few things in the chat specific for getting started, making sure that you have the estate planning workbook. Okay, so let's go ahead and get started. And if you haven't already, you can go ahead and download the workbook there. Okay, so again, my name is Crista Hermance. I am an estate planning attorney. Our firm is Hermance Law. You may know us on social media as Estate Planning Mom, Estate Planning Dad. This is our awesome team. I started the firm about 10 years ago at this point as a new mom, really just wanting to be able to have that balance between being able to have that life balance between being a mom and growing my family while also being an attorney. And this is really what has developed over the years into an amazing team that works really well together to serve our clients while also being very family oriented. I want to go through our agenda for today. So I have some real life scenarios to share with you. I'm going to talk about what probate court is. We'll go through that estate planning workbook that you were able to download. I'll talk about how much estate planning cost, the discount you get for completing a trust plan with us, and then those next steps to get started. And as a bonus, I do have a free advanced healthcare directive that you can get at the end and be able to fill it out to have an advanced healthcare directive if you do not already have one. Okay, so four things, sorry, I added another one on there, that I think proper estate planning could have prevented if a plan had been done. And these are stories from cases over the years that I think are really important and help bridge the gap between real life situations that can happen and how estate planning could have prevented them. Okay, so the first one is involving an investment account and divorce. So this was a case where my client's sister passed away, and we were having to go through the probate court process to distribute her assets that her sister had. And as she's going through the assets, she finds this investment account, and she contacts the investment company, and they tell her that they're very sorry, but the money has already been distributed. And so at this point, my client tells me what's going on. I call them, and I come to find out that the investment account had a beneficiary listed on it, and that money was distributed to the beneficiary, who was the ex-husband, and they had been divorced for over 22 years. Um, the only thing that we could think of is that perhaps when she was going through and she had that marital settlement agreement at the end, she thought, if this is the account is now in my name, there's nothing else I need to do. And so this is a really important takeaway, is check your beneficiary designations, because they do need to be updated, because even if you have an estate plan in place, if your beneficiary designation isn't updated to who you actually want, it doesn't matter, right? It's what is ever listed there. So check your beneficiary designations. When my client's sister had never gone through estate planning, she didn't work with an attorney to figure out what accounts she had and what assets, to figure out how they were titled. And so this is something that is really important to do as part of that estate planning process, to be able to go through and look and see who beneficiaries are on different accounts. Okay. Next one we have is minor children and life insurance. So minor children and life insurance is a really big area for a lot of the families that we work with, right? That have minor children, have life insurance policies. So I was working at a like a community event, and I was at the table, and this mom comes up to me, and she's got 3 little girls with her, and she says, I recently lost my husband. And I said, I'm so sorry to hear that. How are you doing? And she said, I'm doing better. Luckily, he had this life insurance policy for us. And I said, that's great to hear. How is it going for you? And she said, well, at this point, my husband didn't list me as the beneficiary on the life insurance policy. He listed my 3 minor children. And I know what this means because I'm an estate planning attorney and I see this every day. And I asked her, I said, how is it going with getting the life insurance policy? And she says, well, for whatever reason, I have to go to court and get guardianship of my 3 minor girls to prove to the life insurance company that I have guardianship over them, even though they're my children, for them to even be able to release the money to me. And I said, I understand. Are you moving forward with that? And she goes, at this point, I don't even have the mental capacity to even deal with it. And so this mom that has her husband recently passed away, she had this life insurance policy that she should have had access to. And unfortunately, the way that the beneficiary designations were set up, really was hindering her ability to move forward without getting court intervention. And so this is, a really big life lesson for a lot of families that just list their minor children as beneficiaries. Even if it's a backup beneficiary, minor children in the state of California can't actually inherit money or property. And so it would have to go through the court process system where they would get access to that money when they turn 18 years old. And so it's really important that there's proper estate planning done that takes that into consideration if there's minor children. And I asked the mom, I said, did you and your husband did you do an estate plan, or did you have any type of will or anything in place? And she said, it was always on our to-do list and was just something that we never got to. And so this is the perfect example of a family where estate planning is crucial. Had they had those meetings with the attorney to discuss the different ways to title assets and how a plan would have come into play, it would have been a lot of information that probably would have had them make some different decisions on how stuff was done. Okay. Next one we have is adult siblings and parents home. And if you have any questions at any point, please feel free to put those in the chat. I'll try and get to those as we're going through the presentation. And if you're just joining us, welcome. You will get a recording of the replay to be able to watch it at a later time, but we're just getting started. Okay, so adult sibling and parents home. So this was a case where my client, she called in and she said, my mom passed away and it's just me and my brother and we get along great. Can you just transfer my house or my mom's house to me and my brother? And I said, let me do a little bit of research and see what's going on with title. So I pulled title. I called her back and I said, I'm so sorry. But at this point, unfortunately, because the home was owned in your mom's individual name, we actually now have to go through probate court to get it to you and your brother, right? To get it transferred to you and your brother. So it ended up taking them almost a year. It cost them about $18,000 in attorney's fees. And we were able to get it transferred to them. This was an average home, probably worth about $700,000 at the time. And it could have been prevented had mom had a trust. If mom had had a trust and that house been in the trust, the conversation with daughter and those actions after would have been a lot different, right? It would have been, we could have got it done at a fraction of the time, at the fraction of the cost, and really just been able to keep it less stressful for the kids having to go through that whole probate process. Okay, question just came in. So if my parents' house adds my name as joint tenancy, does it mean there's no probate and no estate tax after they pass away and I inherit it? Great question, Nina. And I'm going to say, please, 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 please do not have your parents add your name to title. This is a way that can avoid probate court. The issue that I have with this is that the property could get reassessed, so property taxes could go up. You also get no step up in basis. And so without you inheriting the property, if you went to sell that home at any point, you would have to pay the capital gains taxes from the time that your parents purchased it until the time that you actually sold it. So there's a lot of things that can go wrong that people don't understand at the point where somebody just adds an adult child to title of the home. Okay. Great question. Okay, next one, and the last scenario we're going to go through, the blended family and the unintentional disinheritance. So this was a case where my client, her mother had gotten remarried very late in her life, and she, for whatever reason, had the family home that my client had grown up in, and she added her new husband to title to this property. Um, my client's mom passed away very unexpectedly with no estate plan in place. And if you can guess what happened, the new husband, got the home. And this is why I say this was an unintentional disinheritance. Had mom known by adding her new husband to title, we don't think that she would have done it. We don't think that she would have wanted to disinherit her only child. And that's why we would say this is an unintentional disinheritance. I will say that this case lasted years. It costed a lot of money and emotional stress for my client. And she did end up settling in the end and was able to get some money. But this is all stuff that could have been prevented had proper estate planning been done. Okay, let's talk about what happens when you don't have a plan in place and something were to happen to you, right? Or if you're watching this and you have family members that you're watching this for and taking this into consideration, right? Think of it in their circumstances. So, what happens when you don't have a plan in place? Well, with no plan, there's three areas that we look at. The first is relating to minor children. So if something happens to both parents of minor children, then generally it would be a family member or a close family friend that would come forward and petition the court for guardianship of your minor children. The problem that you have here is the court has no idea who you would actually want in this role because there was no legal documentation done saying who you would want to be as guardians because godparents don't work, siblings aren't automatic. Your grandparents aren't automatic. The court's actually making a decision on thinking who is going to be in the best to raise these children. And so you could have somebody raising them by court order because that's who the judge thinks is going to be in their best interest. What we look at is incapacity. When we think about incapacity, it's when somebody doesn't have the mental ability to really my house and it's no longer going to be in my state and my other kids don't get access to it. It's medical decisions as financial decisions, right? When we think about that, and so see this in people, maybe there was a stroke or Alzheimer's, dementia, conservatorship that would be court intervention where a judge is deciding who is going to be the one who's going to be in charge of the person who's incapacitated to make financial decisions and to make medical decisions. And again, this is one where without proper estate planning documents in place, the court has no idea who you would want. So they may put somebody in that role that you would never want to be in charge of those decisions. The last thing that we look at is when somebody passes away. And this is where probate court gets involved. So when somebody owns assets in their individual name, right? So maybe their house is titled in their name. And, it's important to make sure you understand how title is held. To look at that and to be able to savings account, investment accounts, anything that doesn't have a beneficiary designation or a joint account is assuming it goes over the limit of what probate court would be needed. And so probate court is the process that when somebody passes away, all of those assets go through this probate court process. Somebody files a petition being named as the personal representative of the estate. It is then their job to safeguard all of the assets, start gathering them, send notice to creditors, publish notice in the newspaper. And when they start gathering all of the assets, they can't distribute anything at this point, but then it's going to be maybe selling assets, putting them into an estate account. And at the end, once all the bills are paid, creditors, attorneys, once all those bills are paid, then it's going to be having the ability for the court to then say, yes, you have permission to distribute the estate, and then it's distributed according to intestate succession is what we would call it, right? Who are your heirs? Who is in your family tree? So generally, when people understand what probate court is, they generally want to avoid it. And so probate court is a really long process. It can take anywhere from 1 to 2 years to complete. It is a public record, and it is also very expensive. And so to give you an idea of how expensive probate court is, let's say that there is a home with a fair market value of $490,000. And when I say fair market value, it's not how much the home is worth, it's how much it would actually sell for. So $490,000 fair market value and $10,000 in various bank accounts. So a total probate estate of $500,000. The statutory fees for that $500,000 estate would be $26,000. In addition to that, you have court filing fees, bond fees, publication fees, probate referee fees. That's another $2,000 to $3,000. That's almost $30,000 for a $500,000 estate to go through probate. And it just keeps going up from there, right? Depending on the value of the estate. The other thing that I'll mention with minor children is that if there are no planning documents in place, again, minor children cannot actually inherit money or property from somebody who's passed away. And so it would have to go through the court system where they would get access to it when they turn 18 years old. Okay. Okay, this next slide is something that's going to be in your workbook. It's right after the table of contents. It just gives you a really kind of visual idea of what probate court is. Okay. Okay, next I want you to think about what your asset level is. You don't have to answer it in the chat, but what I want you to do is just think about, what's the fair market value of your home, bank accounts that you have, investment accounts, anything that makes up the value of your estate. Try and come up with that number because we're going to come back to what it could be or how it would be affected with probate cost. Okay. Okay, so for this webinar, we are going to go through 5 different areas of planning documents: power of attorney, advanced healthcare directive, HIPAA authorization, will, revocable living trust, and guardian nomination for minor children. So if you can, take that workbook out and start actually filling in who you want in these various roles as we go through them. Okay, the first is power of attorney. So the power of attorney is a legal document that gives your agent the ability to make financial decisions on your behalf if you are unable to do. Going to the post office, going to the bank, filing tax returns, anything that if you didn't have the mental capacity to be able to do, they would be able to act in your place. Power of attorney. In California, we have the ability to do what's called a springing power of attorney. And so what that means is that if you're in good health right now, you don't necessarily need your agent to be able to act. It only springs into effect upon your incapacity. Okay. The other one that's really important is when you're completing a power of attorney is you want to have 1 primary and at least 2 backups, right? So for a total of 3 people that are listed in those documents. So if you can, go ahead and put those agents that you want in your documents now. If you're married, your spouse could be primary. They don't have to be, but generally the rule here is anybody that's over the 18 that you're going to trust to be able to access your money. Okay. Okay, next we have Advanced Healthcare Directive. So this is a document very similar to the power of attorney, but where you give an agent the ability to make healthcare decisions on your behalf if you are unable to do so. In an Advanced Healthcare Directive, which is also known as a living will, is the ability to put certain end-of-life decisions. So do you want cremation? Do you want burial? Would you want to do any type of organ donation for transplant purposes or none at all? If you are in a persistent vegetative state, would you want to be kept on prolonged life support with extreme measures or taken off? So the Advanced Healthcare Directive, this is going to be one that they may not be the same agents as your power of attorney. Again, if you're married, it could be your spouse, but it doesn't have to be anybody that's over the age of 18. But it's people that you know are going to be able to act in a very stressful situation that if you were in a very bad situation, are they actually going to be able to make those decisions? So with this role, as well as any of these roles, it's important to check with your agents to make sure that they are okay acting on this, acting in this role for you. Okay. The one thing I will mention about HIPAA authorization is a document that maybe you want somebody involved where they can get information and talk to doctors, but you don't want them making decisions. That's where you would put them on the HIPAA authorization to give them that ability. Okay. Okay. Next, we are going to go to the will. So the will is the most common estate planning document that we see. Um, and the will is a legal document where you give specific instructions to be carried out after you pass away. In your will, you say how you want your assets distributed. It also allows you to nominate guardians for your minor children. Once somebody passes away, that is actually when the will comes into play and is filed in probate court. And so if somebody just says, oh, I don't really need an estate plan, I have a will, that's all I need. Well, you have to remember a will does nothing unless somebody has died. So if somebody gets sick, a will doesn't do anything. It's a power of attorney that would come into play to be able to help with financial stuff, right? But then you have to remember with a power of attorney basically cuts off when somebody passes away. And that's where you would need a will or a trust to be able to come in to handle things after someone has passed away. Okay. If somebody doesn't have a will when they pass away, California has an estate plan for them. Again, it's that term that I called intestate succession. And it's basically California's estate plan of what does your family tree look like, right? Who gets the stuff depending on, if you're married, if you have children, if you have parents, siblings. It kind of just goes down from there. So every family situation is going to be different depending on who they have in their family. The biggest myth that I hear when it comes to wills is that having a will avoids probate court. And this is not true. Okay. Having a will is basically guaranteeing probate because it's telling the court, here's how I want my assets distributed. And so it's not having a will is not what avoids probate court. That is having a trust. And we're going to talk about that next. Again, if you have any questions and you're watching this, please put your comment in the chat and I'll try to get to those questions. Okay, so let's talk about trust. So a trust is, we refer to it as a revocable living trust, a living trust, a revocable trust, or just a trust. And a trust is basically just an agreement. And it's an agreement between the grantor, which is the creator of the trust, and the trustee. The trustee is the person who agrees to hold legal title to all of the assets in your trust. And they do this for the benefit of your beneficiaries. So while you are alive and you have a revocable living trust, you are all three of these roles. You are the grantor, meaning you created it. You are the trustee, meaning you are in charge over all of the assets in your trust. And you are also the beneficiary. All of the stuff there is for your benefit to be able to use. You're not losing any control. Okay. So the biggest myth I hear for trust is that, trusts are just for the wealthy. I'm not Bill Gates level. I don't need a trust. But in the example I gave where daughter called me after mom had passed away, that's the perfect example of where a trust would have come in to a situation where if mom had the trust, it would have prevented the son and the daughter from having to go through probate court and pay all of those fees having to go through probate court, right? It would have been a lot less because they wouldn't have had to go through that long process. Okay. So once people understand what probate court is and how a trust can help, it's important to understand what some of those benefits are of having a trust. So a trust can allow you to set up sub-trusts for your children to be dispersed at ages that you set, like 25, 30, 35. A trust also allows you to protect your children's inheritance from predators, creditors, and divorce. Maybe, if your spouse now were to get remarried, right? Making sure that that blended family situation didn't happen where there was that unintentional disinheritance. Having a trust allows you to choose the trustee to manage your finances for your kids. It could be the guardian, or if you have adult children, maybe you would want your adult children to be in charge. When you have a trust, it's private, which means little to no court involvement, which means less money actually being spent. Another really great benefit is listing your trust as a beneficiary on accounts. So maybe that life insurance policy that I've talked about, instead of it going to the minor kids, you could say, well, I would want my spouse as the primary and then my trust as the backup. And then that way, if something happened to me and my spouse, that money would go into trust to be distributed to my kids at age 25, 30, 35, right? You have the ability to create that of what those requests are, or what your instructions are in your trust, okay? Because it's private and it's specifically for you and your family. Okay, let's move on. There is another diagram. This is specific to a revocable living trust. You'll find that in that workbook there. If it kind of just, again, visual to help you kind of see what a trust looks like, how it works. and let's move on to guardian nomination. So guardian nomination, again, this is for guardians, for children under the age of 18, we look at two things: guardian nominations for long-term and short-term. So long-term guardians, we want you to choose guardians that share your same parenting style. They have the same values as you. They will provide the best love, education, and support for your kids. You are the best parent for your child. But if you couldn't be there, who would you want in that role? As a mom with young kids, this is the hardest thing to think about, right? This is why people don't do estate planning, because they don't want to think about being there without their kids, and they don't want to think about who that's going to be, so they just don't, right? The problem with that is, again, without having that guardian nomination, if something were to happen, the court has no idea who you would actually want in that role, okay? The other side of this is short-term guardians. So it's important to choose guardians that, short-term guardians that if there was some type of accident, that can be to your kids within 30 minutes, right? The idea here is we're trying to prevent Child Protective Services from coming in, taking the kids out of the home and putting them in foster care. And so it's really important with both long-term and short-term guardians, you have those protections put in place for your kids, okay? Okay. All of these documents that I've talked about, it's not just one, it's all of them together that make up a comprehensive estate plan or a complete estate plan, right? Guardian nomination, power of attorney, a will, trust, advanced healthcare directive, HIPAA authorization. It's not just one or two, it's all of them together that actually provide that protection. Okay, so after hearing everything that I've talked about, do you think you might need some type of estate planning documents in place? Yes. Anybody over the age of 18 needs some type of estate planning documents, but especially if you have minor children and or own a home, you should have estate planning documents in place. So let me go over the services that we help you plan for to make sure that you have the protections in place, making sure that your wishes are known, giving you the peace of mind that you deserve. So our basic trust package comes with a basic revocable living trust, pour over will that includes guardian nomination, power of attorney, advanced healthcare directive, HIPAA authorization, trust certification, estate planning summary, general assignment, personal property memorandum, memorial instructions and funeral wishes, our trust funding toolkit. It also includes 2 virtual meetings with the attorneys, um, uh, support from our team, which is comprised of phone, email, and our client portal. If you have a primary residence, we are going to prepare the grant deed transferring ownership from you to you as the trustee of your trust. We are also going to prepare the assessor's office form, letting them know, hey, you're transferring your property into your trust. There's no reason to reassess. We get all of those documents recorded because we want to make sure your house gets put in your property into your trust correctly. Your documents are signed in a virtual notarization. If you are not local to one of our signing offices, you will get a portfolio with our estate planning documents mailed to you, a USB drive with a scan of all of your documents, our trust funding toolkit, and any workshops and events that we have. Okay, all of the planning that we do is done on a flat fee price. That means we have trust packages starting at $4,495 for a single person, $4,995 for a married couple. Okay. Because you attended this webinar and you watched this, we are offering a webinar discount. So it's $500 off a trust package, which means that you can get your estate plan done. For a single person, it would be $3,995, and a married couple would be $4,495. So now I want you to think about that cost, right? They're around the $4,000 mark for getting all of those documents in place, that whole plan that I talked about, that $4,000. And think about, what if you were to get sick? The documents that you need when somebody gets sick are a power of attorney, an advanced healthcare directive, and a trust. Okay, that's what's needed when somebody gets sick. Without having those documents in place, that's where a court's conservatorship would be necessary. That can be somewhere between $6,000 to $10,000 to get the court's conservatorship. So doesn't it seem like paying that $4,000 now to be able to have a plan in place so your family didn't have to get a conservatorship and pay up to $10,000 for it, right? Financially, doesn't that make sense? Not to mention it's what your wishes are of who you would want to be in that role. The other thing we look at is, what if you were to actually pass away? That $4,000 that you would pay for an estate plan, I want you to think back to what that fair market value is of your assets. What are your assets made up? And just understand the probate fees that are associated with that that value of an estate. $600,000 estate would be $30,000. $800,000 estate would be $38,000. $1 million estate would be $46,000. 1.2 million would be $50,000, and 1.5 million would be $56,000. In California, 1.5 million could be a primary residence and a rental property. That's $56,000 that would have to come out of that estate. And what I am seeing a lot of is families that inherit these properties through probate court can't actually afford to pay these fees that are associated with the estate. And so they're actually having to sell the property to be able to afford to be able to put these things through probate court. So doesn't it seem like financially making sense that you could get a plan for around $4,000 and save on all of these fees? I want you to take the money outside of this equation at this point and just think about something else. If something happened to you and your family had to deal with your death, it is a very large burden on them to not have any planning documents in place. And I'll share one last story with you as I wrap up. So I had a client who called, and her mom had just died, and she said, I'm so angry. I'm so angry at my mom for not having any of these documents in place and not having any plans. And all I have to do right now is all this paperwork that I can't just be sad that my mom just died. And like, this is a conversation that I will never forget, because had mom done this plan, it would have taken this huge emotional burden off of the daughter. And that's really what estate planning does, is it's providing that peace of mind. It's removing that burden from your loved ones in a time when they are grief stricken and they are going through a lot emotionally, that this is one less thing that they have to worry about. And that's what estate planning can do. Okay, I'm going to go through our estate planning process, share a few things with you, and then we're going to get this wrapped up. So our estate planning process starts with booking a family planning appointment. We will send you an email with an online worksheet for you to complete and submit that online. You will then have a virtual family planning appointment with one of our attorneys. During that family planning appointment, you will design a plan with the attorney to fit your family's needs to ensure that your wishes are documented. And then you sign your estate plan about 4 to 6 weeks later. Okay. Now, for you to get that webinar discount, here's the steps to be able to get that $500 discount. So you're going to pay the FPA fee today, or when you book that appointment. It's $349 and it is non-refundable. You're going to schedule your virtual family planning appointment with the attorney within the next 3 days. So when you schedule that appointment, that's when your FPA fee needs to be paid. And I will say the FPA fee is not in addition to. What it does is it just goes towards the cost of your plan. So then when you go to pay for the rest of your plan, when you meet with the attorney, it's just going to be subtracted that $349 out from what your plan cost is. Okay. The family planning appointment should take place sometime within the next 2 weeks, which is when your payment will be due. If either of these things are not done, then we cannot offer you that discount to get your planning done. Okay. One thing that I will ask of you, if you would be so kind, is to leave us a review. And I'm going to put a link here to be able to put that in there for you. Just give me 1 second. And I do see another question that came in, so let me read through that. And then if you have any other questions, please put that in there. And then I'm going to read through this question as well as put something in the chat for you to leave us a review. Again, this is if you found value in this webinar. It's really helpful for other people that need this information and maybe are just, they don't really know what to expect. So it's great when people can share experiences. I do see some questions that have come in, so I'm going to get to that. And I did put the comment there for you to be able to leave a review. So if you can click that link. I want you also just to keep in mind other services that we offer. So it's not just the estate planning side, but the other side, right? When somebody has actually passed away, these are things that we help with. If there's probate court, if there's trust administration, a lot of times we see property issues after somebody's passed away. Families don't really know what those next steps are. And we are here to provide support and help during that time. If you are ready to book your family planning appointment and design a plan to protect your family, I'm going to put that link in here for you to be able to do that. As well as, don't forget, I have not forgotten about the Advanced Healthcare Directive. I will get that saved here for you to share with you at the end. Let me just get this link in here for the workshop to be able to book your family planning appointment. And then I'm going to put the Advanced Healthcare Directive stuff in here for you as well. And I do see some questions that have come in, so I'm going to start going through those. And you should have a few things in there to be able to click. So getting your appointment scheduled and your free Advanced Healthcare Directive is also getting put in there for you. Okay. So if you're ready to move forward, please book or click that link to book your family planning appointment. Again, it's 3 days from today that you would be able to get that book to get that $500 off. And I did post the free Advanced Healthcare Directive link in the chat as well. So you can go click that link to be able to get that free Advanced Healthcare Directive. Okay, I do see some questions that have come in. And so I am going to look at the questions now. Okay, if I put my house under the trust, will I still have the federal tax credit of $250,000 when I sell the house? What tax credit are you talking about? So when you put your house in a revocable living trust, it's still like you're not losing any ownership of it. So from a tax perspective, it's still your social security number that is that's associated with it. Any tax questions, I would definitely refer to a CPA about what tax credits you may have. But I haven't seen any issues where when clients go to sell. We have clients all the time. They have a trust. We put their house in their trust. They sell their trust. I'm sorry, they sell their house and they just sign the deed as the trustee of their trust and it gets sold. And they're not losing any federal tax credit. I do not see a response to that. So hopefully answered that question. Okay, another question that came in. I'm a divorced mom with a minor child. I have a life insurance policy. Can I just list my kid as a beneficiary or my sister? Okay, so great question. And one, I'm going to say do not list your minor child because, again, minor children cannot inherit money or property. So it's really important that you do not list a minor child there. The other thing I'm going to say is please do not list your sister. And the reason for this is you trust your sister. She's who you would expect to be guardian for your daughter. But what happens is you are basically just giving, let's just say it's a $500,000 life insurance policy. You're giving a gift of $500,000 to your sister. Your sister is probably amazing and will absolutely do the best that she can for your daughter, but she has no legal obligation to give that money for the benefit of your daughter. And I'm not saying that she wouldn't, but what could happen is, what if she had a creditor issue and they came after that money? What if she got in a car accident and her money, her insurance couldn't cover it? They can come after that money. What if she got divorced? I'm assuming she's married, but what if she got divorced and now she had taken that money where it wasn't clear that it was separate property and maybe her soon-to-be ex-spouse is trying to get half, right? Or worse, what if your sister passed away and that money that is in an account that was meant for your daughter is now being distributed to your sister's kids because it was her money as a gift from you, okay? The scenario here, best case would be to create a trust. You can list your sister as the trustee, and then she has a fiduciary responsibility to keep that money separate and keep it protected for the benefit of your daughter. And then you can list your trust as a beneficiary as on the life insurance policy, so that money goes into trust, again, that your sister gets to manage for your daughter, but it isn't in your sister's name personally. Okay, great question. Okay, again, if you are ready to book that family planning appointment, please make sure to click the link here. I just reposted it so you can see where it is in the in the chat. Click there to get your appointment scheduled. And then what I will also, it looks like I have one more question that's come in here. Okay, if I own property in another state, what am I supposed to do? Okay, so a lot of times people don't understand what happens when there is other property owned in other states. And so when you own a property in California, and let's say Nevada, Arizona, Texas, there would be a probate in every state that you own property, right? Because that property in that state would then have to go through a probate in that state. Whereas if you had a trust, you could say, I have my California trust because this is where my primary residence is, this is where I live, and I want to put my Nevada, my Arizona, and my Texas property all into the name of my California trust. Now, if something were to happen to you, your executor or successor trustee would be able to then go in and sell the property, rent it out, do whatever needs to be done. That's the wishes from you, from your trust. And they don't have to go through probate, right? It would avoid having to go through probate for those houses that you have. Okay. Okay. I do not see any other questions that have come in. So I want to say thank you so much for joining me tonight. I appreciate it. I hope this was valuable for you. Again, take advantage of that $500 discount. Book your appointment to get your estate plan done. And you should get an email also with a replay, as well as the link to get your appointment scheduled if you weren't able to get it off the chat. So thank you so much and have a wonderful evening.